my name is Jennifer from Ambrogio, Pletter Associates. The purpose of this video and series is to provide some general information about the bankruptcy process, what to do if you are in foreclosure, including using the foreclosure mediation program, and some general information about obtaining a loan modification. This information is intended to be a guide and is not intended to replace the legal advice of an attorney. The information contained in these videos applies to the state of Connecticut. State laws vary, so consult an attorney in your own state. You should call Attorney Pletter for more details at 203-378-6675. You should seek a bankruptcy attorney if you find yourself in the following situations. If you are only able to make minimum payments and you are not reducing the amount you owe. If creditors are suing you or calling your home or place of work. If you are using credit cards for groceries because you have spent your paycheck on credit card payments. If you aren't saving any money for your future because of debt. If you find yourself in any of these situations or in any other financial stress, you should contact a bankruptcy attorney. In Connecticut, call Attorney Pletter at 203-378-6675. You may file a Chapter 7 bankruptcy 8 years after the previous Chapter 7 filing. If you are married, you may file a bankruptcy petition together with your spouse as a joint petition, or you may file alone. Each spouse may also choose to file separately. If one spouse files bankruptcy, the other spouse does not have to. If one spouse files and the other one does not, the non-filing spouse may be responsible for the debt. You should review both spouses' credit reports carefully with your attorney before deciding if both spouses should file. No, retirement accounts that are ERISA qualified are not considered property of a bankruptcy estate and are not taken away from you by the trustee. ERISA qualified accounts include 401ks and IRAs and most pensions. Social Security benefits are protected from creditors in bankruptcy. Even before you file bankruptcy, your Social Security benefits cannot be taken or garnished by creditors. If anyone dies within 180 days of the date you filed a Chapter 7 bankruptcy, and if you inherit money, then the bankruptcy trustee could use a non-exempt portion of that inheritance to pay your creditors. If you file a Chapter 13, then an inheritance from a death within 180 days of filing could result in a higher percentage being paid to the unsecured creditors. In order to file bankruptcy, you will need to show the court what your debts are, what your income is, what you own and what it's worth, your monthly expenses, and transactions that you have been involved in during the past 4 years. In order to show the court this information, you will need to provide your attorney with many documents, including tax returns, pay stubs for up to 6 months, your credit report, a market analysis or appraisal of your home, a profit and loss statement if you are self-employed, mortgage statements for all mortgages, auto loan statements, and bank statements. The first step is to contact an attorney. It would be a good idea to start gathering your financial documents. These would include pay stubs, lists of your debts, and recent bank statements. In Connecticut, contact Attorney Pletter at 203-378-6675.